minority shareholders in general, right? You have public money, and you don't want to give the control to executive directors. You have independent directors to watch what these executive directors are doing.
Okay.
So, considering all those things, your independent directors are not only sitting there to protect the interest, but also help the board of directors, the other members, right? As it is written, like a coach, like a mentor, so that whatever proficiency they have, experience they have, they can deliberate that in the board meeting or to guide them so
Okay.
that the company is on the right track.
Okay. Okay.
Anything else? We can afford to discuss today because there is very minimum left on balance chapter members. Look, anyone has any doubts, it is a time to discuss. Don't shy away from discussing. Yeah.
Can I know what is the chapter name which is currently going on, sir? Because from the past 2 weeks, I had my BCom exams and I was able to attend the classes.
Okay, members. I think members or shareholders, right?
Members and
Members. Chapter 3.
Chapter 3. Okay, sir. Thank you.
Likit, you can get in touch with any one of your friends here. You can
Yes, sir.
discuss the points that we did in last 2 weeks.
Yes, sir. I'll do that, sir.
Yeah, yeah. Please, I mean, you can help him out. So you will also brush up your concepts by explaining to him. That is how you start learning. Right, we'll start. Okay, just a second. Can you tell me page number, please?
Page number will be in book it is 157, Manoj,
157. Okay.
but in the PDF the numbers here and there goes.
Okay, okay, just a second.
Which page, Siddharth?
157. One second.
Veto power.
No, no, before that,
Okay, collective membership rights was done. Voting rights of members. Section 47. Nomination by security holders. Shareholders democracy. I think Manoj, it will not it will be one page before, I think, because
okay, come to page number 142. We'll speak about BO. Look, SBO, I want to take it in next class. Okay, it's a bit challenging topic. We'll only discuss BO and other things today. SBO in the next class.
correct.
Page number 142. 142 steps for declaration of beneficial interest.
Yeah.
I missed this class actually, Manoj. I was late from office.
Okay. You can go through, madam. You can go through if you have any doubts. In the next class, we might discuss.
Yeah.
Right? It's a pretty simple chapter only.
Okay.
Members. Beneficial ownership. We discussed, right? Anyone can just brief out. BO.
One company holds all of the shares for the sake of compliance. They will appoint one more person as member, and those benefits also will go to that company. That company is
Correct.
beneficial owner.
Yeah. That may be one example of a BO. Look, BO beneficial owner is usually for the sake of compliance only it is done, or genuine case it may be done even for non statutory requirement also. What happens is that registered owner, right? He his name is only entered in ROM as registered owner, but whatever benefits that the share get that he gets out of the shares that is holding goes to the beneficial owner if he has declared someone else as a BO. What is that benefits? It may be your dividends. It may be your rights issue, which I'll tell you there is a separate chapter for that. Capital raising. Okay. So likewise, any restructuring, bonus issue. So whatever is there, benefit will go to the BO, right? For the sake of registration, the member will hold the shares as a registered owner. That's all. You're able to understand, right? So once this happens, there is a process of reporting. Okay, it is given in page number 142, steps for declaration. Siddharth, can you read out?
Yeah. Steps for declaration of beneficial interest in any shares. Rule 9 of the company's Management and Administration Rule 2014. A person whose name is entered in the register of members of a company as the holder of shares in that company, but who does not hold the beneficial interest in such shares, shall file with the company a declaration to that effect in form number MGT4 within a period of 30 days from the date on which his name is entered in the register of members of such company.
Okay, so what happens is that suppose Siddharth is a member. He has got an allotment. Okay, his name is entered in ROM. Now he wants to declare the benefits to someone else. In that case, it is a physical form. MGT4 is a physical form. He signs it and delivers to the company. Okay, within 30 days. Yeah, Siddharth, next.
When any change occurs in the beneficial interest in such shares, the registered owner shall, within a period of 30 days from the date of such change, make a declaration of such change to the company in form number MGT4.
Same. So today he has authorized me as a beneficial owner. Okay, tomorrow he can change someone else. Okay, he is saying, okay, let us make Kushal as a BO. In that case, also within 30 days from the change, you need to submit this physical form MGT4 to the company.
Okay.
Yeah,
Every
next.
every person holding and exempted from furnishing declaration or acquiring a beneficial interest in shares of a company not registered in his name shall file with the company a declaration disclosing such interest in form number MGT5 within 30 days after acquiring such beneficial interest in the shares of the company.
Okay, so once Siddharth declares beneficial owner is someone else, even the beneficial owner, that is me, so I have to declare in MGT5. That is also physical form. So that both has to match. Right. So Siddharth giving declaration and beneficial owner, that is me giving declaration, both has to match. Okay, this is also physical form, it is delivered to the company.
Provided that where any change occurs in the beneficial interest in such shares, the beneficial owner shall, within a period of 30 days from the date of such change, make a declaration of such change to the company in form number MGT5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. 5. Point
Okay.
number 3.
So once what happens after this declaration is received by the company will take note of this, okay, and file e-form MGT6 with the ROC and make a necessary entries in ROM, register of members. We're able to understand the process, right?
Yeah.
First, MGT4 will happen. That is, registered owner will declare someone or to someone as a beneficial owner. That beneficial owner will confirm saying yes, I am a beneficial owner in MGT5. Once both the declaration is received, company will intimate to the ROC in e-form.
MGT6
E-form. This is a e-form.
E form.
Once that is done, your ROM is rectified. Your ROM is entered.
Okay, third point. Where any declaration under Section 89 of the Act is received by the company shall make a note of such declaration in the register of members and shall file within a period of 30 days from the date of receipt of declaration by it and return in form number MGT6 with the registrar in respect of such declaration with fee, provided that nothing contained in this rule shall apply in relation to a trust which is created to set up a mutual fund, a venture capital fund, or such other funds as may be approved by SEBI. Now, can you explain the last two lines?
The proviso.
No, the provided that nothing contained
Yeah,
in the rules.
yeah. So usually this is this thing. What to create a BO, right? This is a format MGT4, 5, and then 6.
Say,
But wherever you are setting up a trust, right, or a mutual fund and a venture capital fund registered with SEBI, you don't have to intimate ROC.
oh,
It is deemed that the beneficial owner is someone else.
okay,
Okay, the only thing is the reporting need not be done because whenever SEBI approves any fund, it is deemed that whichever trust you are making, benefit goes to that mutual fund or a venture capital fund.
got it. So MGT4 and MGT5 is physical form, whereas MGT6 is the E form, right?
Correct, correct. So this is the BO concept, beneficial owner. There is one more called as SVO. It's again very important concept, tricky concept. Okay, I'll take it up in the next class. The intention of SBO is to find out ultimate individual holder who is holding the shares and getting benefit.
Hello.
Take an example. You have an investor sitting in Australia, right? He does not invest funds into India directly. What he does is from Australia he moves the funds to Mauritius. From Mauritius he moves to South Africa. From South Africa he moves to
But I could not update.
what
No,
or again
could not
Australia
update because I was,
and some other country, Malaysia. Then he brings the money to India,
otherwise I would have made it.
right? Ultimately, for an Indian point of view, the money is coming from Malaysia, not it is not coming from Australia, from where it is originated. Now, to find out who is getting benefit out of these shares, you need to track down. That is called SBO. So you ultimately you are finding out the individual who is controlling the company. Ultimate individual. If there is no individual, then there is no SBO. Okay, in the next class I will tell you in detail. But you understood the basic, right? What is SBO? To
Yeah.
track down who is the individual, ultimate individual controlling the company. Look, suppose it's a private company. Two shareholders are there, body corporates.
Correct.
Okay. Now you don't know who is controlling. Now you go and ask the shareholding of the company. They will give you. We have two body corporates. In that body corporate, you will check the shareholding again. Who's the individual controlling? Like that, you will go on checking and ultimately find out who's controlling. right? There are certain percentage and limits. Okay, we will discuss that in detail.
Sure.
Okay. Okay, come to page number 150. Just brush up rights of members. Look, in the exams, you will not be given such straightforward question saying what are the rates of the members. Like they will ask you, Mr. A is a member of the company. However, company failed to deliver dividends or a notice for the general meeting. He has not been receiving notice. Does the law? I mean, any violation is there with respect to rights of a member? Okay. Likewise, the question will be built up. You will not get a straightforward question. You're able to understand, right?
Yeah.
So
It
you
will
need to
be
remember.
like more of a scenario based kind of thing.
Correct. Correct.
You
Correct.
will be put in the scenario, so we have to analyze. Like just now, you said member X were not notified for the general meeting. So in that case, does the company has violated the rules or
Correct.
something? So there we
Correct.
have to
Correct.
trigger the point that each the rights the member had in terms whether it is violated or not. If it that violated,
Exactly.
then in individual rights it should be the company has violated. We should mention the criteria for that.
Yes. Yes. That's correct. Okay. Go back and read it again. We have discussed this individual rates. What are the collective rates of members? Don't read. Just tell what comes to your mind.
Collective rights means a group of members unanimously have the one. I mean, a group who takes up a call, otherwise given them is
Correct. As a group, what you can do? You can call for a requisition meeting, right?
okay.
As a group, what you can do? You can file for operation mismanagement.
So where the in individual rights as an individual we are doing here, it is a group which is performing
Correct. Correct.
together all the
Correct.
requisitions.
Correct. Look, there are certain places in the act wherein it says you need this many number of people or this many percentage of members, right?
Exactly.
So in that case, you need collective effort of all the members. So that is a collective right. What about voting rights of members?
Voting rights.
Who can vote equity shareholder or preference?
Equity.
Equity and
What is the percentage of voting? How is the voting pattern?
Generally, one member, one vote.
Correct. Show of hands, yes. Unless
It's based on shares, number of shares.
unless Paul is demanded. We discussed, right? Paul. Who can call for a poll?
person among the members, one of them.
Correct. What are the criteria?
Look at it.
To start Remembering all this, very important. Right. So usually your equity shareholders vote on all resolutions. Right. Usually it is one member, one vote, unless poll is demanded. Right. Wherever e-voting is there, it is always number of shares. That is postal ballot. Right. Voting by post or electronic voting. In certain cases, equity shareholders also get a vote. Okay. There is a separate chapter called preference shareholders. Uh, I will tell you about. You remember nomination, one shareholder can nominate in case of disease or death. Nominate someone else as a nominee holder.
Yes, sir.
So what is that provision?
Like after a transmission of shares happens after his death.
Yeah, it may be your allotment or transfer, whatever it is, or a transmission. So usually what happens is, in case you are a subscriber to MOA, that is the first start. In that case, your name is entered in ROM, correct? Now, in the ROM itself, you can declare someone as a nominee. So how do you do that? You need to give this form called as SH13 to the company, wherein you declare um someone else as a nominee. So if something happens to you, shares will go to him. So suppose you have not declared, okay, then again that whatever you have declared in the will, that will come into picture. So it is better that you submit this SH13 form. Got it right? So any member can submit a nomination form as SS13. Accordingly, company will record the same. So what is the liability of members? Now you saw the rights of members. What is the liability of members?
To pay the money on shares.
Unpaid
Yeah,
shares.
correct. So in case you have a company having share capital and you have balance payment of that call amount, okay, in case of winding up, you will be called upon to pay. That is in case of company having share capital. What about company having not having share capital?
Guaranteed amount.
Guaranteed. Okay, whatever amount you have given guarantee, that agreed amount you will be asked to pay. Having share capital is balance call. Does not have share capital is whatever amount you have agreed initially, that you will be called upon to pay. Okay, so there is another important concept called as variation of shareholders' right. Okay, page number, just a second, 154. So by virtue of this section 48, variation of shareholders' right, whatever rights that an individual shareholder has can be varied, right? That is with respect to your voting or with respect to your dividend. So what happens is in case of a dividend, look, equity shareholders only upon declaration of dividend by the board of directors gets dividend. You're able to understand, right? You can note it down. There's a separate chapter called as dividend. So dividend only if board of directors declare. In that case, equity shareholders gets dividend. But whereas for a preference shareholder, their terms comes with percentage or an amount that you need to mandatorily pay. It does not require board of directors approval. Okay, it is automatic. So that can be varied using section 48. Or take an example, voting. Like we discussed, one share, one vote. Okay, in case of Paul, that can be varied, right? That saying 100 shares, for 100 shares you hold, you will get only one vote. You're able to understand, right? So for that, what you need is consent of not less than 3/4 of the members, or with a special resolution of a separate meeting of the holder. You can vary. So in order to make the variation, pass a special resolution or get a consent in writing of not less than 3/4 of issued holder. Can you tell me the difference? What is given there? Consent of 3/4 holder and special resolution. Isn't both the same?
Here it's in writing, but here they would give a form, right? They will just have to tick in special resolution.
No. Anyone else?
First one is based on number of shares, 3/4.
Okay.
Second one maybe special resolution, maybe one member, one vote.
No. Don't you think both are 75%? So I'm asking, what is the difference?
With the consent in writing of the holders of not less than 3/4.
Look, in case one, you don't need a meeting. Case one, you just need their consent.
Oh yeah,
Case two, you need a meeting, right? How will you pass a special resolution without the meeting?
right. Point.
You able to understand? So without a general meeting, how will you pass a special resolution? In the case one, you have got a written consent from them. So once you have all the consent, that is sufficient. You need not to hold a meeting. Okay, so variation can be affected if the provision is contained in your memorandum or articles of association. In the absence, you need to alter your AOA or make sure that there is no such thing that is prohibiting alteration. Sorry, variation. One variation should contain in your MOA AOA or make sure that there is nothing prohibiting this variation. Mark it as important. It may be asked for 4 marks. Variation of shareholders' rights. That is with respect to voting and dividend. Who can do it and what are the grounds in which they can do it? Shareholders' democracy. We have discussed this. Section 179, subsection 1. If anyone can remember and tell me. 179 1. Who exercises the power of the company?
Board.
Board of directors. What are the exception?
Restrictions to power of the board.
Yes. Then I am looking for the terminologies which is used in 179 1. We have discussed this. Usually the powers are exercised by the board of directors unless the law uses the word
Resolutions.
resolution passed at the general meeting or resolution requiring special resolution or resolution requiring just a resolution at the general meeting. In that case, your powers are exercised by the board of directors. Okay, if the words are such that it is saying to be approved in general meeting or by way of special resolution and resolution, it needs to be approved by shareholders. Okay, so that is called shareholder democracy. By virtue of that, there are certain provisions which require shareholder approval. So, being a shareholder, you have a luxury to participate in the discussion and make sure that company is on the right track. You're able to understand, right?
Yeah, yeah.
So, by virtue of the provisions of the act, there are certain sections in which it enables shareholders to participate. Okay, so that is called a shareholder democracy, wherein you can keep a check on the company. So being a shareholder, obviously you don't have any access to the control of the board of directors day-to-day affairs, right? So that is the reason shareholder democracy is very important. Siddharth, you can start reading from point number 3, that para 3 of shareholder democracy.
Okay. Shareholders' democracy. Under the Companies Act, the power has been divided between two segments. One is the board of directors and other is of shareholders. The directors exercise their powers through meetings of board of directors and shareholders exercise their powers through general meetings. Although constitutionally all the acts relating to the company can be performed in general meetings, but most of the powers in regards thereto are delegated to the board of directors by virtue of the constitutional documents of the company, which the memorandum of association and articles of association. Under Section 179 of the Companies Act 2013, a general power has been conferred on the Board of Directors. The section provides that, subject to the provisions of this Act, the Board of Directors of a company shall be entitled to exercise all such powers and to do all such acts and things as the company is authorized to exercise and do. Proviso to this section restricts the power of the Board of Directors to do things which are specifically required to be done by shareholders in the general meeting under the provisions of Companies Act or Memorandum of Association or the Articles of Association. Thus, the Companies Act has tried to democrate the area of control of directors as well as that of shareholders. Basically, all the business to be transacted at the meeting of shareholder is by means of an ordinary resolution or a special resolution or by postal ballot.
Okay, look at few of the instances where you need shareholders approval for the following agenda items.
Yes.
Okay, you want to alter your memorandum or articles. The law says you need a special resolution passed by shareholders. Or you want to issue share capital. There is a separate chapter which we will deal. Okay, so in case you want to reduce the capital already issued, or you want to shift the registered office, okay, appoint directors,
To decide a place other than the registered office of the company where the statutory books required to be maintained.
yeah, you're able to understand, right?
Yes. And these points are also important.
Okay, so um, you remember last class we discussed how the issue and allotment process happens.
Yes.
Can you tell me?
Issue in the case where the company first makes the offer,
Correct?
then the offer is subscribed by the investor, and then they make the payment. Once the
Okay.
company receives the payment, the allotment process begins where the shares are allotted to the buyer, the investor.
Okay, so issue meeting, can I do it through resolution by circulation?
Issue meeting.
No,
What is the reason?
powers of the board only should be done through physical or VC.
Correct. So it is given in section 179,
Subsection 3.
subsection 3. What about allotment?
Any means.
It can be done through any means. Okay, so prior to this offer, okay, so prior to the board of directors offering the investors, what happens is you actually meet those investors. Directors go and meet. That is what happens practically. Right? You go search for investors. That is your pitch meetings happens. Right? You demonstrate what is your business model. You demonstrate your revenues, how are you going to make revenues, and all those stuff to the investors. Okay, you make a PPT, give in your pitch. Once they're satisfied, then they agree to invest. That is when this process starts. Issue, then they subscribe, they bring in funds, then allotment happens.
Yes.
Right?
Yes.
Now, prior to that, once the pitch in happens, usually these investors comes with the lawyers, legal team.
Yes. To do the
Okay,
compliance check.
correct. So they want to check uh, the compliance of the company in which they are investing. So they undertake due diligence of the company. Right. So due diligence is process wherein you identify non-compliances. Right. What are the compliances done so far and what are the non-compliances? And they ask you to rectify immediately because that will lead to contingent liability in the balance sheet. Right. Take an example. If you have done a non-compliance, your penalty amount, the defaulting amount that is to the company and officer in default may exceed 30 lakhs or 50 lakhs. Right. So as an investor coming in, by doing a due diligence, you will come to know this is a default and they have to go for a compounding or a adjudication. So that rectification can happen then immediately funding will happen. You're able to understand, right?
Yeah.
So, so once, as I said, pitch in happens, DD will happen, due diligence. Once DD happens, DD report is submitted to the board of directors. Okay, if the DD report is clean, then you have something called as SSA, share subscription agreement. Please write down. It is very important for our next deliberation of next chapter. SSA. You will deal with this a lot when you're into training or practically when so qualified. It's called SSA. So what exactly is SSA? Is share subscription agreement. Okay, a new investor who is coming in, he comes up with his own rights, terms and conditions, how the board should behave, how the company should run, right? What is his role in the company, right? And how much money is going to bring in. Okay, what is the percentage? What is the dilution factor? So all this is gotten in SHA. Sorry, SSA, share subscription agreement. So that is entered between the potential investor and the company. Please remember. Okay, any doubts still here? Okay, so once this happens, SSA is approved. Okay, then what happens is, what happens? Then SHA, shareholders agreement.
Shareholders agreement.
So what is shareholders agreement is, suppose you already have existing shareholders. There are already five people sitting in the cap table as a shareholder who are already having an agreement. So this SSA will form a part of his SHA. Terms and conditions mentioned in SSA will form a part of SHA, shareholders agreement. Again, that is the same thing, similar thing, wherein you have all the other investors, all the other shareholders, existing shareholders, forming party to that agreement with the company. But in SSA, only potential investor who is bringing in the money. But SHA, all existing shareholders with the company.
Yes.
So, any doubts on the process?
So which means what we discussed is there are two more steps that involved is first the offer happens, then
Prior to that,
prior to the offer there is a pitch
first
in
is
happens.
your pitch
First the
meeting.
board, first the directors do a pitch in with the investors.
Correct.
Once that is done, from the investor side there is a due diligence happens,
Correct.
whereby they fix up all the flaws and other penalties and other things. Then there is
Correct.
an SSA happens, which is the share
Subscription
share
agreement.
subscription agreement with
What
the
is that share SSA?
sorry.
What is that SSA?
Share subscription is with the potential investor who is bringing in the money, the between the company and the potential investor who is bringing in the money.
Sorry, what does it contain? Details.
Terms and conditions.
Terms and conditions on which he is giving the money to the company, the number
Correct.
of
What is the money that is bringing in? What is the capital? What is the percentage of shareholding that he gets?
yes.
Okay. What is the dilution interest and all the things that is will be there. Okay. Once that happens,
Once that happens, then it there's a SHA happens. If there is
correct.
with the existing shareholders and the company, between the existing shareholders and the company. Once that is done,
Okay. So this SHA, that is the SSA, the new investor, potential investors, terms and conditions will be incorporated in SHA. Right. Already existing SHA with the company. You're able to
company.
understand, right?
Yes.
Okay. So once that happens, you have to offer shares to them.
Yes.
Okay. Then your subscribers bring in the subscription money and allotment takes place.
Yes.
Okay. Please remember this flow chart. Because once you remember this, next there's something called as private placement. Okay, very very important topic. So that will be very easy.
So
So
just
any doubts here? Yeah,
just repeating Manoj once, it is like the first is the pitch-in,
correct.
then the next step comes is after the pitch-in, then it comes to is SSA with the
Due
potential,
diligence. No,
sorry,
no, DD.
sorry, due diligence DD with the up by the investor. Then the SSA happens with the potential
Correct.
investor, and once that happens, then the after that the SHA happens, where the SSA happens between the potential investor and the company, and after that the terms and conditions and everything is decided. Then it comes to the next step of SHA, where the existing shareholders and the
Company plus
company
new
plus the
investor.
new investors who is coming with them.
Correct.
After the SHA part, the actual offering happens.
Correct. Offer issue happens.
Offer
And
issue
subscriber.
happens, and then offer issue, and then the subscribers, the investors they subscribe, then the money is getting deposited, and then the
In the bank
financial closing
account.
happens.
Correct. Correct. Please do not forget this chain end to end, because this is the entire structure that you will be working on for your lifetime. Okay, so this is how the startup runs.
Sir, like every time a new investor comes, we have to have SHA, is it?
There is already existing SHA, it's only amendment.
Amendment. But still, the old investors who are present, they have to sign, is it?
Yeah, yeah, yeah. You have to. They have to.
Because it is diluting the stakes for
Correct,
everyone. So which party is
correct,
diluting how much percentage?
correct, correct. So it is only a add-on. That is amendments to existing SHA. But SSA will always be new. SHA will be amendments. Today there are 15 investors with SHA. Tomorrow I'm bringing in three more different investors. All three different investors comes with their own lawyers, own drafted SSA. All the three will be included in SHA
Yes.
with the existing 15.
Yes.
So total SHA will contain 18 investors, that is members plus three of plus the company.
Yes. 15 plus 3 plus the company.
Correct.
So in SHA, then it will be calculated as 18, or it will be calculated as because
18, 18, 18, 18.
only the shareholders will be calculated who are getting added to.
Correct, correct, correct. Okay. Uh, Siddharth, read 156 shareholders agreement.
Shareholders agreement. Yeah. Shareholders agreement. Shareholders agreement SHA are quite common in business. In India, shareholders agreement have gained popularity and currency only lately with bloom in newer forms of business. There are numerous situations where such agreements are entered into: family companies, joint venture companies, venture capital investments, private equity investments, strategic alliances, and so on. Shareholders agreement is a contractual agreement between the shareholders of a company describing how the company should be operated and the defining SE shareholders' rights and obligations. SHS are the result of mutual understanding among the shareholders of a company, to which the company generally becomes a consenting party. Such agreements are specifically drafted to provide specific rights, impose definite restrictions over and above those provided by the Companies Act. SHA creates personal obligation between the members signing such agreement. However, such agreements do not become a regulation of the company in the way the provisions of articles are.
You're able to understand, right?
Yes.
Now tell me one thing. I am an investor. I am Alibaba. I am from Alibaba Group from China. Right? I want to make investment in Swiggy. I speak to the board of directors. I tell them that um, whenever you want to make a investment or whenever you want to raise a capital, you need to take my permission. So that is my terms. So if you are in agreement with this, I will invest money. Okay. Now you tell me whether this is allowed.
That point.
Yeah.
What
So
is it?
as an investor,
Hmm.
in my SHA, I'm telling the board of directors that whenever you make or you want to raise a money or you want to make an investment or issue any capital, you need to take my prior consent before doing that assignment. Okay, whether that is allowed or not.
No, because it comes under the power of the board, right? Section 179.
Correct. But as per the agreement, they are only saying in order to do that, you need to take my permission. If I give you the permission, then you can do it. Because that is how the SHA is. That is my terms and conditions. Otherwise, I will not bring in the money. You're able to understand, right?
Yes.
Today, example, I am Alibaba Group. I give 50 crore to Swiggy. In my agreement, I'm saying Swiggy cannot borrow more than 10 crore from any bank. If they want to borrow anything more than 50, anything more than 10 crore, you need to have my specific permission. If I don't give my permission, then you can't, board of directors can't do that, can't undertake that activity. That is my terms and conditions. Or board of directors cannot appoint a new director unless I give a consent. They need to take my consent, then they can appoint a new director. That is my SHA. If you are okay, I am giving in 50 lakhs, 50 crore. So now what is your thought?
It becomes like a holding company, almost.
It may be one of the terms of that. Not necessary that you are able to establish that 50% and controlling the composition of the board. Not necessary you are able to establish that. Even otherwise, once you are able to establish, obviously you become a holding company. I'm saying even otherwise, if you're not able to establish that relationship, and yet you want to have this kind of look, this is what the investors tell you. There's something called as reserve matters.
Yes.
In order to deal with the reserve matters, you need to take the investor consent. That is the terms and conditions.
I think there was a similar case, the same case what happened when Amazon put that restriction on this future group. When they were trying to sell the assets to Reliance Group, he went and put an obligation in the court of law saying, without my consent, you cannot sell that.
Correct.
That was the similar example.
Tell me, is it anyway violating the articles of association or it is anyway becoming stricter?
Stricter.
So can you say it is allowed?
No.
Allowed, right?
Allowed.
Right. Anything over and above the articles which you are making is stricter, it is allowed. Please remember.
Yes. Oh, sorry. Yeah.
Or anything over and above that it is given in the act you are doing, it is allowed. So as an investor, yes, whatever powers are given in the Companies Act, you will establish, you will do as a board of directors. I have no problem. But before doing that, you need to take my permission. That is what I'm saying. That is what it is written in SHA.
Just like I'm strict, I'm making it stricter for my action to protect.
Interest, correct. I am bringing in 50 crore. I want to make sure that the company is in the right track, right?
Yeah.
I want to know each and every activity of the company.
Because if the company over debts also, it will be like they will start misusing the funds.
Exactly. That is the reason as an investor, every investor comes up with their own terms and conditions. It's a reserve matter. Look, for example, I have handled Swiggy when I was in doing this consultancy. They're called as Bundle Technologies Private Limited. You can Google. But the brand name is Swiggy. They have about 15-20 investors from across the globe. With every investor, if the company wants to raise a fund, they need to take 20 investors' consent. So being a secretarial team, being a company secretary there, imagine. You need to go back to each and every investor and get a consent for the reserve matter. Saying board of directors wants to raise 100 crore. We are requesting your consent because As per the SHA, it is a reserve matter. Kindly give your consent. You're able to understand, right?
Yes.
Now, what happens if now I say take an example, Swiggy, there are about 20 investors. I do not take their consent. Still, I've gone ahead and do it. What happens?
Contract Act.
Breach of contract, correct? It is a breach of contract. But as per the provision of Companies Act, I cannot be held liable. Company cannot be held liable. Why? Because contract is different. Indian Contract Act, I will go and file there. It does not come in company law jurisdiction. You're able to understand. In order to bring in that to company law jurisdiction, that is NCLT and NCLAT, what the lawyers do, they incorporate the SHA matter in the Articles of Association. Please remember that. They alter the AOA. They bring in the terms of conditions provided in SHA. They bring the same clause in your AOA because they want protection under Companies Act. They don't want to file under Indian Contract Act.
So which
You're
means
able to understand.
so you are telling like the lawyers they put that clause in the AOA of the company.
Correct. Correct. So that it is enforceable as per the Indian Companies Act.
So but this is done by the investor side lawyer or the company side
How is special resolution passed?
from
Who
company.
passes that?
Huh? Yeah.
Obviously, right?
Yeah. So which means
So what they do is practically once the allotment is done, right? Once the allotment is done, there is another board meeting and a shareholder meeting called for restatement of AOA.
yes.
So you already have articles of association. Now you are restatement of AOA. You call for a general meeting, pass a special resolution. You incorporate the changes, the terms and conditions of SHA in the articles. That is when shareholders' rights are protected as per Indian company law. Otherwise, what happens if you're just having SHA, if you're not making that provision in your AOA, then you cannot fight in Indian law as per Indian Companies Act. You cannot go before NCLT, LAT. You have to go before civil courts under Indian Contract Act. You're able to establish. You're able to understand, right?
Yes.
Any doubts still here? Any doubts? We can repeat.
As per in the book, SSA is not mentioned, right?
No. This is practical thing that I told you. Okay, Siddharth, you can read that enforceability of shareholders agreement.
Yeah. Enforceability of the shareholders agreement. Though the international view is split, but to a large extent, courts are inclined towards favoring SHA as long as they are not found to be detrimental to the minority stakeholders' rights. In the leading case of Russell's versus Northern Bank Development Corporation Limited 1992, BCC 578, 992, 1, WLR 588, the House of Lords found that though a company cannot deprive itself of its power to alter its constitution, the members of the company could agree in a shareholders' agreement as to how they will exercise their voting rights on a resolution to alter the articles of constitution. The US courts have largely accepted shareholders' agreement.
Okay, 1 minute. So this is international code, right? So this is a practice outside India. So outside India, yes, shareholders agreements are also accepted as equally as your AOA. Okay, now you read the Indian part down.
Sure. While shareholders' agreement are enforceable in England, regardless of whether they have been incorporated in the Articles of Association of the company, in India, courts have either refused to recognize clauses in shareholders' agreement or, even when consistent with company legislation, enforce such clauses only if they have been incorporated in the Articles of Association of the company. There is a series of rulings where the courts have upheld that in case of any conflict between the articles and the SHA, the former will always prevail. Some of these are following cases.
Okay, you're able to understand, right?
Yes. The case in case of any conflict between articles and the SHA, the former will always prevail.
So your articles, your SHA, SSA, your Companies Act, which prevails? Any conflict?
AOA.
Articles of Association or SSA, SHA, your Companies Act, what prevails? Any
Article.
conflict?
First articles.
First,
Articles.
Spiritor will be there. Articles, right?
Companies Act.
Will be there.
Yeah, tell me. I want the section number. I want.
Rule section 6.
Yeah, what does it say?
If there is any contravention between AOA and
No, it's not contravention, conflict.
conflict between
Contrary.
AOA and Companies Act will prevail.
Yeah, please remember, as long they are in line with the Companies Act, your articles, your SSA, SHA, they will be given identity. But as long as you are deviating from the provisions of the Companies Act, it will be null and void. Because your Companies Act prevails over everything. Section 6 of the Companies Act. Okay, tomorrow in the exams you will get a question saying, as per the agreement, the investor in the reserve matter needed to take consent from the investor before declaring dividend. Now advise the company on whether they can go ahead and declare dividend without their consent. Or company has already declared the dividend, what is the remedy? You're able to understand, right? So what will be your answer?
Can you repeat again? What is it?
Look, so they will say, as per SHA, okay, a company needed to take a consent from an investor for a declaration of dividend. Company has not taken their consent. However, company has gone ahead and declared dividend. Now advise the company whether the declaration is valid as per the Companies Act. Declaration of dividend is valid.
As per Companies Act, it's valid because SHA doesn't come under purview of CA Companies Act. So complying with the articles, they have done correct.
Okay, can you just put it correctly? Or anyone can put it just correctly in the right sequence? So first you will say that we need to check what? Whether SHA is incorporated in the AOA.
AOA, okay.
Right? So once that is incorporated, then obviously you are violating the provisions of the Companies Act. Okay, so then the declaration may be challengeable. Declaration of dividend is challengeable in the court of law. However, SHA provisions are not incorporated in the AOA. In that case, company has declared dividend, it is holding good. But I am in default of SHA. That I will fight it differently. That will not affect my declaration of dividend. You're able to understand, right? Okay, now come to page number 157. Veto power. Okay, in the terms and conditions, they have this something called as veto power. That is, they can restrain you from doing it. Please remember, right? It is only negative It is negative wording, which means not providing their consent, but they're saying you can't do this. That is a veto. Suppose company wants to borrow 100 crore from bank. If the investor has a veto power, then they will exercise this, right? So which means company cannot go ahead and do borrowing of 100 crore. You're able to understand, right?
Yes.
That is incorporated in your SHA veto. What is the difference between veto power and a casting vote? What is casting vote? Tell me. Chairman casting vote.
You're telling seconding vote, is it?
Correct.
Like when there is 50-50 of the decisions being made, like equally for and against, the chairman will take second vote where he goes either way.
Correct. So only in that case of equal a vote. Correct.
When it is a deadlock situation kind of thing where it
Correct.
is
Correct. So in veto it is different. Veto it is only you're giving a negative this thing, saying you can't do this. Come to page number 150, 158. 158 last part. Assignment of office. Assignment of shares in a company. We discussed this, right? Shares are always freely transferable
yes.
unless it is a
Private company.
private company. You're able to understand, right? Does the shareholder of public company require board of directors approval for transfer of shares?
No.
Why?
They are freely transferable.
Free to transfer. Where it is written?
Definition.
Definition. Only definition of private company says restricts transfer of shares. Public company, there is nothing defined. Okay, practice this specimen shareholders agreement. Okay, you never know, you may get this for 5 marks. Okay, it's very simple. So any doubts?
Sir, not related to this, but in the charge section, if they have not registered, it will become unsecured creditors, right?
Correct.
In the waterfall arrangement, unsecured creditors comes below or above secured creditors?
Below, always below. Your secured creditors will be given more priority.
Sir, but when I saw, right, we have a SPAC, we have that waterfall arrangement. There it was first, and then the public secured creditors will come.
Your first your employees, government department, all those comes, right?
Then
Then your
unsecured.
secured comes. Then you have last unsecured creditor.
Okay.
Just go back and check.
Okay, sir.
Okay, your unsecured comes at the last. Meaning after all your government department, your employees, okay, your overdues to authorities, then secured creditor, then after secured only unsecured.
Okay, sir.
So any doubts on today's class? Only pending today is SBO.
Yes.
Okay, next we'll do that. Okay, come to page number 164. We'll just brush up. I think few of them didn't attend last class, so we'll take it up from question number 1.
Every shareholder of a company is known as a member.
Okay, yeah, anyone can read and others can answer.
Every shareholder of a company is known as a member while every member may not be known as a shareholder. Comment.
Okay, what is this exception?
During the transfer of shares.
Correct. So can you like clearly explain to all?
Like when a person, clearly a person will be a shareholder and a member when he owns the
So
shareholder,
usually, your members and shareholders are termed synonymous, right?
interchange.
So both are called same,
Same.
unless in what circumstances?
When a member transfers his share to
Okay,
another person out of the
correct,
company, so
correct,
that shares will be given to the other person.
correct,
So he'll not be called shareholder because he doesn't own the share, but he'll be still member because his name will be entered in the ROM. Until it
correct,
is removed, he cannot be removed from the term member. Uh,
correct. So whenever the transfer happens, right? So I transfer the shares to Siddharth. Until my name is removed from the ROM, I will be considered as registered member. Okay, and for the time being, Siddharth will be considered as shareholder. Okay, unless Siddharth's name is replaced in ROM, register of members. Till then, he will be considered as shareholder. Okay, next.
Who can become a member of the company? Can the following person or institution become member of a company? Minor.
Okay, yeah. Minor, can he become a member?
Mm,
No.
Guardian. You can.
Yeah, through the guardian, he can hold shares. What about member? Can he become a director?
Through transmission.
Sorry, minor become a director.
no,
No.
What is the reason?
because he cannot hold that. He is not eligible to have a DIN, so he is
Okay.
not authorized to become director because he is not eligible to become hold a DIN number.
Okay, what is the eligibility for becoming a managing director? What is the age limit? Minimum and maximum.
18 and 70.
No, one is correct.
18 is correct.
21 is
21.
21, MD 21. Maximum?
70.
70.
Okay, still can I go ahead and appoint a 80-year-old managing director?
Special resolution.
Special resolution has to pass from the board of the director.
From the members. Special resolution you need to pass. Okay. Yeah, Siddharth, continue.
Uh, Second option, company.
Can a company become a member in other company?
If it is registered and
Yeah, registered company. Yeah. Next.
Partnership firm. No,
Can a partnership firm become
no,
member?
because it's based on the date, so there cannot be
Not a legal entity.
legal entity.
Partnership firm is not a legal entity. Can a partner of that partnership firm hold shares in his individual name?
Yes,
yes,
What is the reason?
he's a legal person.
Individual, in individual name he can hold. Partnership firm per se cannot hold. What about LLP?
Can move.
What is LLP?
Limited liability.
partnership.
Yeah, what is the features of LLP?
Features limited liability
Same
legal.
like a company. It is a hybrid of a company.
and
Right. Only thing is you don't have a board of directors. There you have partners. Right. Okay. Next.
Foreigners. Yes, a foreign national can hold shares. Can become a member.
Subject to. You need to complete.
Yeah,
Tema.
subject to
Right.
FEMA.
Just say. Don't say yes or no. Complete the entire sentence. Insolvent.
can't.
Okay. What I am a member. Suppose I am already a member. Okay. I become insolvent. In that case, do you remove me as a member?
It will be nominee will be there. Right? It will be transferred to nominee.
That's not the right word for insolvent.
Official assigning.
Assigning. Right. So assignee will. So that person will take over. You're able to understand, right?
Yes.
Okay. I am an insolvent member. Can I be expelled from membership?
You cannot expel a member.
You cannot expel the member. Please remember, members cannot be expelled. You're able to understand, right?
Yes.
Okay, next.
Is a subscriber to the memorandum of the company would be termed as member of the company.
Yes or no?
Yes,
Yes.
deemed member.
Deemed to be the member.
Deemed to have agreed to become member of the company.
Okay. Question number 3.
Describe the circumstances under which a register of members may be rectified. Illustrate your answer in the light of the relevant provisions of the Companies Act. Under which a
So
register of
I think
members
there
may
are
be
2 or 3
rectified.
cases, right, where ROM can be rectified.
Yes. That's fine.
One is the member has not given his consent to enter his name in the ROM.
Yes. Three
Can
other.
you read out quickly all 3 points?
Where name of a person is entered without sufficient cause.
Okay.
Where his name after entering in ROM without sufficient cause is omitted.
Okay.
No, no restriction. Others, if you have written, you can tell. I'm searching.
Or only two or three.
Three are there. One more I have not written. Anybody?
Yeah, Siddharth, go to the next question.
Okay. What? Okay. The name of X is found entered in the register of a company, but X contends that he is not a member of the company. The company
Okay.
maintains that X had orally agreed to become a member and hence his name was entered in the register and so he is a member. Is the contention of the company valid?
Hmm.
By point acquiescence and estoppel, he has remained silent, so his name he'll be held liable. But
Okay.
if in the court of law, if he has found it's entered without his knowledge, he can.
Yeah. Acquiescence or estoppel, that point, right?
Yes.
Yeah. Next.
What are the obligations of a person whose name is entered in the register of members of a company as holder of shares but does not hold beneficial interest in those shares?
He should give NGT4 within 30 days.
Question number 7, right? Or 6.
Question
Six.
number 6.
Okay. What are the obligation of person whose name in?
Entered in the register of members of a company as holders of shares but does not hold beneficial interest in those shares.
Correct. So his obligation is whenever there is a change or initially he has to make a disclosure.
Yes.
Okay, MGT for physical form, MGT 5 for BO, and company will file E form MGT 6.
E form MGT6.
4 and 5 is filed to the company, right?
Correct. Company in turn will file with ROC in MGT
In E
6.
form MGT6. What is the meaning and procedure for declaration of significant beneficial owner? SBO. Okay, that's
Okay,
the
SBO
next
next
question.
class. Yeah, next
Yeah.
class.
What are the individuals and group rights of members?
Okay, quick 5 individual rights and 3 group rights.
Group rights to further capital if they want to uh, issue shares.
No.
Uh, to issue shares.
What are the individual and group rights of members? Individual rights are right to receive copies of the following documents: financial statements, consolidated financial statements, and auditor's report, and every other document required by law to be annexed or attached to the financial statement, section 136. Uh, Abridged financial statement and auditor's report in the case of a listed company. Report of the cost auditor if so directed by the government. Notice of the general meeting of the company. Again, section 101 to 102. One number two, rights to inspect statutory registers, returns and get copies thereof without payment of any fee or on payment of prescribed fee. The members have been given the following rights. Point number three is right to attend meeting of the shareholders and exercise voting rights at these meetings either personally or through proxy, from section 9600, 105 and 107, and other rights. In terms of group rights, that is collective membership rights of group rights.
Yeah, next question.
The statement liability of the members of the company is always limited is false. Explain the with reason. Explain with reasoning. Statement liability of the members of the company is always limited.
Yeah, is the
Does
statement correct or not?
no. If it's unlimited, sir. But this statement can it be related to the first chapter where it's also that can be the
Yeah,
state.
yeah, it can be.
Okay.
So liability of members is always limited, right? There is certain exceptions given in chapter 1. What are those you can remember?
Like at the time of inspection, if the inspector comes to know that the shares, the loan was taken to deceive the creditors,
Okay.
and one more. Prospectus was issued to deceive creditors.
Okay. There's more.
When it is unlimited company by articles.
Correct. Page number 20. exceptions to principle of limited liability.
Or when any take an undue advantage, any KMP.
Page number 20. Okay, next question.
Write short notes on cessation of membership of a company, foreign register, index of members, variation of members' rights, registration of shares in the name of public officer, veto power, and casting vote.
Tell me from the first cessation of membership of a company. What does a member cease to become a member?
When he transfers his shares,
Okay, that is one, correct.
when he becomes insolvent, unsound mind.
Oh, yes, correct. Unsound mind, yes. Then,
When he dies.
yeah, correct. Transmission happens. Then,
When the company wound up or wind up.
yeah, correct. Okay, next. Foreign registers. Can you explain the process?
Foreign registers is maintained outside India. If there is any foreign members,
Members, debenture holder, or any security holder. What is the process?
part of it is maintained. It is signed by CS or a director or any other authorized person by BOD.
Correct. So entries in foreign register has to be done in India too. Same entries, right?
And it should be the notification should be given to ROC.
Correct. Which is the form?
Form MGT3.
MGT3. Perfect. Okay. Yeah. Next, index of members. So entry should be in chronological order. Okay. If it is less than 50, you need not to have this index. If it is more than 50, mandatory. Variation of members' right. Variation of members' right. Today we discussed. What are the two ways in which you can do it?
Oh,
Take consultant writing
Written
for of issued shares or
Three-fourth.
resolution.
3/4.
Yeah.
Yeah. Or pass a special resolution. Right. So what is that you need to make sure? Your AOA or MOA should authorize or it should not prohibit. Okay. What are the things that you can vary?
Voting rights, dividend.
Voting rights and dividend. Yes. Okay. Point number E. Registration of shares in the public office. What does that mean? Registration of shares in the name of public office.
like on a regular interval, it should be filed to ROC, right? All the register which we maintain.
No, it should not be filed. No. Yeah. Anyone? Okay, go back to the next one. This is specifically covered in next chapter. I mean, chapter number 2.
Veto power and casting vote.
You know, right? Veto power and casting vote.
Yes.
Can you tell me what is veto power and casting vote?
Casting vote is where the situation of the meeting reaches to a deadlock situation where neither of the vote reaches. The chairman uses his second vote power to deciding the on the resolution, and
Okay.
veto power is when you oppose that restrain something.
From happening, from taking forward.
Yes.
Okay, yeah. Next,
Which all companies are required to comply with the provisions of Section 90.
1 minute. That is given in. Again, this is SBO. I'll take it up in next class.
Okay, what is the meaning of beneficial interest?
Yeah, what is beneficial interest?
When the interest of the shares are not being transferred to you, but it's been transferred to the majority shareholder,
No.
not majority.
Same we discussed now that registered owner, beneficial owner.
Yeah, registered
Whatever,
on.
yeah, the whatever rights, the benefits that is given in registered owner, that is transferred to beneficial owner, right? So that is called beneficial interest.
Last one. In case of
Last
a
last text, previous chapter number 2, covered in chapter number 2. So one 4 marks question is compulsory from this chapter.
And who owns veto power, sir?
Investor director.
Investor director. Is there any special agreement that needs to be signed? Something.
That is only your SHA.
Okay.
With your SHA, you will have all these conditions.
the one that you said where the investor puts the restriction that if the company goes for withdraw taking a debt, they restrict that without my consent you cannot go. That's itself is like a veto. Is putting up the power like as I take.
No, that will be that power will be given in your SHA. That is your incorporated in your AOA.
Correct.
That will be exercised by the in the meeting, board
Yes.
meeting. Look, practically nowadays, your nominee director, investor director, that concept is slowly fading away. Reason being is, if you look at 166, it does not discriminate between directors. Does not discriminate between nominee director, WTD, executive director, independent director, right? 166, section 166, same for all. So, being a nominee director on the board, he does not have full of control over the affairs, right? Only to the extent he can control that is given in your terms. That is the reason nowadays you will not have this nominee director, but you will be considered as advisor to the board, which means without being a director, as an invitee, you are attending the meeting as an advisor. So in terms of the liability, you're not liable as per the Companies Act because you're not director. But however, being an advisor, board of directors will take your advice. That is a prevailing concept, prevailing trend now. Board advisors. Come to page number in the this thing. Page number 6. Page number 6 in the book. Module 1, Executive Program Module 1.
Page number?
6. That index, syllabus.
Yes. 7. Yes.
Okay, so if you look at it, there are important concepts which are given here only. Like, for example, take chapter 3, members and shareholders, right? So there it says how to become a member, registers of member, declaration of beneficial interest, rectification. You're able to see all this. So by looking at this, you need to answer. These are the very critical from an exam's point of view. They will just pick up these lines, then they will give you questions. So once you finish reading the entire chapter, come back to this index, ask yourself whether you can answer this. You're able to understand, right?
Yeah.
So whenever you're done with the chapter, come back to index, start answering these questions. If you are familiar with these concepts, then no way you're going to get less than 60. That is for sure. Okay, and those of you who have not started studying, please start. High time. Don't take it till the last. And also, whatever questions that we are discussing at the last, please start answering. Write down the question. Once you read, no, okay, now write it down for a 4 marks or a 5 marks. With that intention, start writing down notes. Then go back to the section, then see what are you missing out. Start practicing question and answers now. Because you may answer everything in the class, but there for 4 marks, you will just end up writing 2 marks. And then in the exams results, it will not show good. Right? Practice writing answers. Okay, any doubts on today's class or anything that we want to discuss another 5 minutes? Then we'll wind up. See in that chapter, see charges. Point number 5, chapter number 5, creation of charge. So once you read it, you should able to recollect how do you create charge, what is the registration, how do you modify, and what are the satisfaction, register to be maintained, who can inspect, punishment. Get these concepts very, very clear, thorough. They will just pick up these lines and they will give you questions. That's all. I think clearly more than 55 marks we have covered till now. Right. Now with this 55 marks, I expect you to at least score over 35-40. So if you are able to score out of 55, 35, 40 and balance 35, 45, you can score another 30. So 65, 70 is your target. So that it can set off on other subjects too. Okay, any doubts? Will before we wind up, anything is fine. Or whenever you are reading, you can ping me or call me. That's fine. Not a problem. Don't get the concepts wrong. That is my humble request. Because if you are getting the concepts wrong, you will write the wrong answers in the exam. Then we'll wind up. Okay, please go back and revise. Right? And we'll catch up on Monday.
Sure. If anything, we'll ping up you over WhatsApp.
Yeah, any doubt while reading, if you get any doubt, you can message me or you can call me if I'm busy again. I'll call you back.
Okay, sir.
Okay.
Right. Thank you.
Okay. Bye bye.
Thank you.
Right.